The Matrix and the US Constitution. Author unknown. Introduction. During my 12 years service as a judge, I always insisted on the truth and placed justice above law and order. I could have prepared this article indicia of a research paper. However, people tend to lose interest when articles of this nature become too technical. Science has taught us that for every action there is a positive reaction. If your life on earth resembles a matrix, it is because you're seeing things for the first time with eyes wide open, but you feel confused. That feeling of confusion is appropriate because the information you are now digesting contradicts much of the information you've been spoon-fed throughout your life. I named this paper after the movie The Matrix, written by the Wachowski brothers. After reading this, watch the movie and you will notice many similarities. In 2002, my brother ran into a problem with the IRS, and to help him out, I began to research the tax code. One thing led to another, and suddenly I was uncovering information about our government, which was directly in conflict with the US Constitution and what I've been led to believe throughout my life. In time, I began to interface with people from every state in the Republic who were doing the same thing I was doing, some for the same reason and others for different reasons. We began to trade our research, and the facts I uncovered was totally in contradiction to the history of America, which had been taught to us in public school, and the principles of law I'd absorbed during my service as a judge. I began to assist people to prepare and file suits in the courts, and I filed several of my own. At one point, because of the information I'm about to provide to you, I became extremely depressed. After about 3 months, I eventually shook it off and continued on with my research. My hope in writing this is to help you, the reader, make sense of it all, which will require you to wash your mind clean of the brainwashing you were subjected to by our government-controlled public schools and churches, and re-educate yourself. When you understand the actions, the reactions will make sense, and it should anger you. Eventually, you will have a choice to make, a choice that will define how to survive life in the Matrix. In the Matrix, nothing is real. However, your mind has been conditioned to believe it is real. The Matrix is far too big to defeat. No one can escape it, and we haven't the means or intelligence to beat those in control. Through my research, I discovered that America is a society of functional illiterates. I remind you that this is not my opinion. I'm just the messenger. I first read Silent Weapons for Quiet Wars in a book entitled Behold a Pale Horse by William Cooper, who is an ex-naval intelligence officer who was killed by police officers. In this particular document, you will find a lot of different documents that a lot of people borrow from. This book came out, I read it back in 1991, and over time I've become even more enlightened by this book as my knowledge has grown over the years. I would suggest everyone get a copy of this book and put it in their library. It has a lot of valuable information in it. But you can see right here on page 35, you'll see chapter 1, excerpts from Silent Weapons for Quiet Wars, copy furnished by Mr. Tom Young, a fellow warrior in the cause of freedom. Excerpts printed word for word exactly as discovered. The added comments of William Cooper, emphasis added by William Cooper. The Illuminati's declaration of war upon the people of America. William Cooper's author's note. I read top secret documents which explain that Silent Weapons for Quiet Wars is the doctrine adopted by the Policy Committee of the Bilderberg Group during its first known meeting in 1954. A copy found in 1969 was in the possession of Naval Intelligence. The following document, dated May 1979, was found on July 7, 1986, and an IBM copier that had been purchased at a surplus sale. Top secret, Silent Weapons for Quiet Wars, an introductory programming manual, operations research. And a lot of people say this is a fake document, just like protocols for the Learned Tales of Zion. But anyone of any intelligence that does a cursory examination of any of these documents will quickly come to the conclusion that the level of information and technicality required to write a document like this would make something as something as people just blowing it off as fake, either make them look like they're a damn fool, or they got to be some kind of agent, or they don't want y'all reading this. That's the only conclusion I can come to. let's read it and let's see. I'm not going to read the entire thing, but there is a section I do want to show you about the educational system, about being dumbed down. And it's in the energy system where he talks about energy. And this is a very, very good part of this particular document. And I'm going to start right here. I'll read this entire thing. It is real good, the entire thing on energy. Energy is recognized as the key to all activity on Earth. Natural science is the study of the sources and control of natural energy. And social science, theoretically expressed as economics, is the study of the sources and control of social energy. Both are bookkeeping systems, mathematics. Therefore, mathematics is the primary energy science, and the bookkeeper can be king if the public can be kept ignorant of the methodology of the bookkeeping. All science is merely a means to an end. The means is knowledge. The end is control. The end always justifies the means. Beyond this remains only one issue: who will be the beneficiary? In 1954, this was the issue of primary concern. Although the so-called moral issues were raised, in view of the law of natural selection, it was agreed that a nation or world of people who will not use their intelligence are no better than animals who do not have intelligence.
I think the most recent thing, you mentioned it before, and the most important thing, became involved in a lawsuit in 2006. I was added as the last of 7 defendants in a case that involved the manufacture and distribution of a controlled substance. The controlled substance was colloidal silver, but it's the same law that they would apply with heroin and cocaine, and it's a part of the drug laws. It was a civil prosecution by the Attorney General of the state of Texas, and they added me as a defendant. I was fiduciary for a trust. The trust was a defendant. They made me a defendant, and they're suing every defendant, including me, for $25,000 a day. That's $9 million a year. I guarantee I don't have that kind of money. And it sharpens your attention quite a bit to be sued for that, especially by the Attorney General of the state of Texas. I started reading the relevant law, and I'm a student of the Bible, and I have an understanding of the Declaration of Independence and fundamental principles, and I was just shocked. I read the law, and the definition of drugs presumes the people to be animals. And when I first saw the language, I thought, my God, these damn fools, they don't even know what they're writing. And then I saw it a second time. And then I saw it 2 more times in the federal law. First, I found it in the Texas law, then I found it in the federal law, and we found it in 23 separate laws and regulations that applied in our case. And it's abundantly clear that the government has been treating the people as animals. This is the foundation of our war on drugs. The war on drugs laid the foundation for much of the modern police state. The police state gave us the prison industrial complex. And all of this is balanced on a couple of little definitions of drugs and medical devices that presume the people to be animals.
Leviticus 25:45. Moreover, of the children of the strangers that do sojourn among you, of them shall ye buy, and of their families that are with you, which they begat in your land, and they shall be your possession. And you shall take them as an inheritance for your children after you, to inherit them for a possession. They shall be your bondmen forever. But over your brethren, the children of Israel, you shall not rule one over another with rigor.
אוקיי.
לא. נו, תגיד.
רגע, אני רוצה, רגע.
יש לנו בני אדם, מה?
אוקיי, אז השאלה...
נו, יוסי, תגיד שלא.
אתם קוראים מאוד
הם חיות. אתם קוראים בהמות, כתוב, אתם קוראים מאוד ואינם קוראים מאוד.
זהו, אבל לא הם בהמות.
נכון, לא כתוב שהם בהמות.
אבל יש לזה הסבר על זה, נכון? למה הם... רגע, זה מה שאני רוצה להבין. רגע, שקט. אז מי, כן, מה כתוב? זה מה שאני לא מבין.
כתוב שאתם קרויים אדם, והגויים לא קרויים אדם, זה מה שכתוב.
לא קרויים?
לא קרויים אדם, לא קוראים להם אדם.
אוקיי, אז מה קוראים להם?
אדם הוא בן אדם שהוא שונה מהבהמה.
אוקיי.
אם הבן אדם עושה את מעשה הבהמה, אז הוא כמו הבהמה, מה זה שווה? כל בן אדם צריך לשלוט על עצמו.
אוקיי.
זה היהודים שולטים על עצמם.
אוקיי.
אם היצר אומר להם לעשות דבר והם לא עושים, אז הוא בן אדם.
אוקיי, אבל יש מישהו שהוא לא יהודי, שעושה מה שצריך, הוא בן אדם או לא בן אדם?
גם כן. צריך לעשות דברים נורמליים. בדרך כלל הם עושים, הם יכולים להרוג אנשים כשלא רואים אותם. יהודי לא יהרוג יהודי, אפילו שלא רואים אותם. אם אחד גוי, כן?
אבל יש יהודים שהורגים יהודים.
יש.
יגאל עמיר, רבי פופר.
יהודי שמתנהג כמו יהודי, ודאי יש יהודים שלא מתנהגים.
אוקיי, אבל רגע, מה שאני לא מבין, זה כל הגויים הם איך קוראים?
תקשיב שנייה, אדוני.
בהמות.
אני יכול להגיד לך משהו?
אם אין להם ציווי.
אדם זה על שם הדמה לעליון. אדם זה כי הוא יכול לדמה לאלוקים. אוקיי? זה פירוש אדם. אנחנו הפכנו את זה, זאת אומרת העם הפך את זה. האדם בן אדם, כמו אתה בן אדם, אתה צריך להתנהג כמו בן אדם. אבל בעיקרון זה על שם עליון. אדם זה הדמה לעליון, וכיוון שאנחנו בנים של אלוקים, אז הוא קרא לנו בני אדם. ועכשיו, הגויים מה שאין, כן? אלוקים עשה אותם בשביל שיעשו פה...
בשביל לשרת את היהודים.
Protocol number 1. Putting aside fine phrases, we shall speak of the significance of each thought. By comparisons and deductions, we shall throw light upon surrounding facts. What I'm about to set forth, then, in our system from the 2 points of view, that of ourselves and that of the Goyim, in other words, non-Jews. It must be noted that men with bad instincts are more in number than the good, and therefore the best results in governing them are attained by violence and terrorization, and not by academic discussions. Each man aims at power. Everyone would like to become a dictator if only he could, and rare indeed are the men who would not be willing to sacrifice the welfare of all for the sake of securing their own welfare. What has restrained the beasts of prey who are called men? What has served for their guidance hitherto? In the beginnings of the structure of society, they were subjected to brutal and blind force, afterwards to law, which is the same force, only disguised. I draw the conclusion that by the law of nature, right lies in force. Political freedom is an idea, but not a fact. This idea one must know how to apply whenever it appears necessary with this bait of an idea to attract the masses of the people to one's party for the purpose of crushing another who is in authority. This task is rendered easier if the opponent has himself been infected with the idea of freedom, so-called liberalism, and, for the sake of an idea, is willing to yield some of his power. It is precisely here that the triumph of our theory appears. The slackened reins of government are immediately, by the law of life, caught up and gathered together by a new hand, because the blind might of the nation cannot for one single day exist without guidance, and the new authority merely fits into the place of the old, already weakened by liberalism. Protocol number 17. The practice of advocacy produces men cold, cruel, persistent, unprincipled, who in all cases take up an impersonal, purely legal standpoint. They have the inveterate habit to refer everything to its value for the defense and not to the public welfare of its results. They do not usually decline to undertake any defense whatever. They strive for an acquittal at all costs, cavilling over every petty crux of jurisprudence, and thereby they demoralize justice. For this reason, we shall set this profession into narrow frames which will keep it inside the sphere of executive public service. Advocates, equally with judges, will be deprived of the right of communication with litigant. They will receive business only from the court and will study it by notes of report and documents, defending their clients after they have been interrogated in court on facts that have appeared. They will receive an honorarium without regard to the quality of the defense. This will render them mere reporters on law business in the interest of justice, and as counterpoise to the proctor, who will be the reporter in the interest of prosecution. This will shorten business before the courts. In this way will be established a practice of honest, unprejudiced defense, conducted not for personal interest, but by conviction. This will also by the way, remove the present practice of corrupt bargain between avocation to agree only to let the side win which pays the most. Now, I don't know if all of you understood that or not, what this was exactly talking about. But anyone who says this is a fake document, obviously they haven't read it, or they don't want you to read it, because when I go through this document, I plan on actually doing a video on this particular document as well. Everything in it is happening. This is how they're setting up the court system. Honorarium is payment. An advocate is a public, is a defense attorney. A proctor is a prosecutor, and so forth. And it's telling they're going to get paid regardless of the defense they give. And don't you see that happening with your public defenders? They're not doing anything. You go around the country and check and see. See if anyone is being properly defended in court. Ineffective assistance of counsel is like the number one thing guys try to get back in court for. So right here, you can see a lot of these things coming into fruition. If you read this document, this is their blueprint. This document was in Behold a Pale Horse, along with some other documents too that were very interesting. Silent Weapons for Quiet Wars, a lot of documents. You should take the time to read this and see for yourself whether this is some fake document or not. Such people are beasts of burden and stakes on the table by choice and consent. Consequently, in the interest of future world order, peace, and tranquility, it was decided to privately wage a quiet war against the American public with an ultimate objective of permanently shifting the natural and social energy, wealth, of the undisciplined and irresponsible many into the hands of the self-disciplined, responsible, and worthy few. In order to implement this objective, it was necessary to create, secure, and apply new weapons, which, as it turned out, were a class of weapons so subtle and sophisticated in their principle of operation and public appearance as to earn for themselves the name silent weapons. In conclusion, the objective of economic research, as conducted by the magnates of capital, banking, and the industries of commodities, goods, and services, is the establishment of an economy which is totally predictable and manipulative. In order to achieve a totally predictable economy, the lower class elements of society must be brought under total control. In other words, must be housebroken, trained, and assigned a yoke and long-term social duties from a very early age, before they have an opportunity to question the propriety of the matter. In order to achieve such conformity, the lower class family unit must be disintegrated by a process of increasing preoccupation of the parents and the establishment of government-operated daycare centers for the occupationally orphaned children. The quality of education given to the lower class must be of the poorest sort, so that the moat of ignorance isolating the inferior class from the superior class is and remains incomprehensible to the inferior class.
This is Luke Radowski of WeAreChange.org, and I am here with Charlotte Isaby, who's an American whistleblower who worked for the U.S. Department of Education. Now, Charlotte, can you tell us specifically what was your position and what did you uncover in the U.S. Department of Education?
Well, my position was very, very important, although I did not have the credentials for it. The hand of God put me into the Office of Educational Research and Improvement as Senior Policy Advisor.
And what year was this?
In 1981.
So this was Reagan?
Under Reagan. Now, I just happened to get plopped into that slot that ordinarily in the past would have been held by the former president of Harvard or Stanford or Columbia, whatever. And so I had access to all the old plans and the new, all of which were geared towards limited learning for lifelong labor, basically, which is what we're looking at today through school choice, tax-funded school choice. That's putting it in a nutshell. It's been the plan ever since the late 1890s.
So it's deliberately lowering the educational system so we would have a dumbed-down public. Why would they do this?
Well,
what's your rationale for this?
Well, because they want workers. They want worker bees. They don't want intelligent people, who will, if you know what's going on, you might want to do something about it. They don't want individualists. They want collectivists. They want people that can be dictated to, moved around on the slavery, basically. Slavery, basically. Slavery, basically.
With such an initial handicap, even bright lower-class individuals have little, if any, hope of extricating themselves from their assigned lot in life. This form of slavery is essential to maintaining some measure of social order, peace, and tranquility for the ruling upper class. The people in charge of the Matrix represent the most powerful and intelligent humans on Earth. When gifted children appear in the public schools of the world, they are courted with scholarships, money, and eventually memberships into secret societies. They'll be introduced to very persuasive intellectuals who will convince these young gifted people that it is their place and duty to be a part of the elite who rule the world's population because the rest of the world's population are too stupid to make decisions for themselves. Their comment, not mine. When the New World Order is officially and openly in control, only the extremely intelligent will be allowed to propagate. Everyone else will be sterilized or murdered through staged pandemics used to eliminate excessive populations. Every foreign revolution, the world wars, the Depression, Prohibition, Korea, Vietnam, the Middle East conflict, and the influenza epidemic during World War I was planned and orchestrated by these people. Many early writers researched much of this history and were forced to fund their own publication and the distribution of their work. Most never received the acclaim they deserved and never knew our government was responsible for their failures. I'm prepared to supply anyone interested with mounds of research in support of what I have written herein. When I conveyed parts of this information in court documents, the opposition's lawyer responds to their client that I'm just crazy, and if the judge is within earshot of that comment, he will nod his head in judicial agreement. Well, I guess that caps it. If a lawyer and a lawyer judge both contend that I am crazy, then I must be crazy. They wouldn't lie to you, or would they? The motive of our founding fathers was totally self-centered. It was their personal greed that inspired them to accept the task of writing the Constitution of the United States and not patriotism. In actuality, the United States is not a land or a place. It is a corporation and a legal fiction that existed well before the Revolutionary War. The Constitution of the United States was written in secret by the Founding Fathers and was never presented to the colonists for a vote. Surely, any document as important as this demanded the approval of the people it governed. Well, it wasn't presented for a vote because the Constitution wasn't created for we the people. It was created by and for the Founding Fathers, their family heirs, and their posterity. The Constitution is a business plan, and any reference contained within it that appears to be the safeguard of a right is there because none of the Founding Fathers trusted each other. The safeguards were intended to prevent any one or group of them from cutting out the others, proving that there's no honor among thieves. Americans are not unlike all other humans who inhabit the earth. All human beings possess malleable minds, which are minds that can be shaped and controlled. And when government shapes and controls a mind, it's called brainwashing. Brainwashing causes the subject to become functionally illiterate. In America, our functional ignorance excels in the areas of history, government, and law, which really are one and the same. 98% of the officials in public office are lawyers, and these so-called representatives set policy and create the laws that govern this society. Their use of Greek and Latin terms in law and the habit of changing definitions and usage of common words is intentional. The intent is to confound and confuse the general public and to hide the treason they are implementing, and so that the members of the public are forced or decide to hire a lawyer out of frustration rather than try to represent themselves in our fictional courts of law. As you read on, I'll explain to you why and how our courts and laws are fictional. The bar. There has never been a law on the books created by the Congress which made it illegal for a common man to practice law. Every judge of a district, circuit, or appeal court, except justices and magistrates, is a lawyer and a member of the bar. These judges have the authority to establish local rules of court, and those mentioned have created a local rule that prevents common people from representing any other person in their court or to practice law without a license. A license requires that you produce your Bar Association number. For those who don't know, the Bar Association is simply a lawyers' union, and when lawyers are accepted into the bar, they're required to swear allegiance to a foreign power. The American Bar Association is a branch of a national organization titled the National Lawyers Guild Communist Party, and can be found recorded in the United States Code at 28 U.S.C. 3002, Section 15A. They become so big and entrenched, they no longer fear reprisal. Whenever I tell people that there is no actual law that makes it a crime to represent another person in court, the reaction is, "That's a lie!" I remind them that Abraham Lincoln and Clarence Darrow never went to law school or passed the bar, but the reaction is understandable because the bar is a very powerful organization and its members have infiltrated every niche of American life and business. How many times in your life have you heard you can't practice law without a license? I've heard it said in numerous movies spanning 100 years, in my mother's soaps, and my comedians and jokes and theatrical skits. I've seen the phrase in print in newspaper articles, magazines, and heard it on the radio. Before I learned the truth about this fact, even my personal lawyer made that comment to me. We all have been brainwashed to believe a lie, and because we've heard it so often from people we trust and who are supposed to have our best interests at heart, we all just assume it must be true. How many other lies have you assumed it must be true? Not long ago, while doing some research, I came across a document that was very interesting. It concerned a matter of a lien filed against the Washington State Bar Association by an ex-attorney by the name of Stephen L. Wozni. And this particular lien has had some international significance associated with it because he has sold this lien to various individuals over the past 10 years. What is interesting is that he hasn't been charged with fraud or anything like that with this particular lien. But there's a document on the internet called Letter to Supreme Court Chief Justice Jerry Alexander. And what it was all about is Wozni had got a default judgment against a judge. And the judge over his case refused to sign it. And he took it all the way to the Supreme Court, and he ended up getting disbarred. So when you look him up on the internet, they're going to call him a fake. You know how they do? They call everybody fakes. He's a fraud and so forth. But if you read this particular document, I think you're going to have a change of heart and have some insight into what this particular bar attorney was talking about. There's a section in there where he actually talks about the Bar Association. And right here on page 3, we read, in spite of the absolute and clear law material to this matter, on the 29th day of October 2002, a private nonprofit organization that claims to be directed by you and, under some fiction, owned by your office, calling itself the Washington State Bar Association, employed members of the 25th largest law firm in the United States with instructions for them to fabricate and send a most vicious and fraudulent attack letter to the Washington State Bar Association's Office of Disciplinary Counsel, a very long and impressive title for something that does not lawfully exist, and a copy to co-prevailing party and co-plaintiff herein, Stephen L. Wozni. It is a maxim of law that no man shall take advantage of his own wrong. Lord Edward C. Coke. Now down here in brackets was something interesting. It says this Washington State Bar Association thing closely resembles a resurrected version of an outlawed 1612 ecclesiastical tribunal, but unlike the 17th century church lawyers they seek to emulate, your vassals more resemble a pack of not too bright but dangerous obsequious hounds. So right here we can see this lawyer kind of revealing some things. Me, myself, I checked on the Bar Association in California because, a judge called me out and said I was practicing, am I practicing law without a license? And I responded, well, I wasn't aware that the practice of law had to be licensed. And after that, we went home and we sent certified mail letters to the bar associations along with a $100 money order for copies of attorneys' bar license. They said they returned and said they didn't have it. They said the Supreme Court has it. We wrote them, and they also said we know nothing of it. And the clerk at the Supreme Court, had put in my letter in her return envelope. She didn't mention it in her correspondence, but she just happened to put a case that was in my envelope, and it was of a gentleman up in Seattle who is suing the California Bar Association, saying that all the attorneys are practicing law without a license. What I found out in doing the investigation is that the Supreme Court allows them to come in and practice law once they get their bar card. There's no real license per se. I've never seen a license. If somebody out there has one, please, pull it out and show us what it looks like, because I have yet to see what a license to practice law looks like. I mean, who is the agency that regulates that? A license to practice law. Never seen one. The Constitution. Our American society has been lied to by the government and lawyers more times than you will sign your name in your lifetime. We've been indoctrinated, brainwashed to believe that the Constitution was created for we the people. The purpose behind these lies is to make you believe that you are free, safe, protected, and secure, and it is all an hallucination. How many of you have studied each line of the Constitution, the statute at large, and the Articles of Confederation, armed with a reputable dictionary or law dictionary from that era? If you take the time to do this, you will soon discover that the true purpose of the Constitution was to create a business plan and to establish a military government for the protection of the Founding Fathers, the King's commerce, protection of his agents, and the future control of his subject slaves. Even the preamble of the US Constitution is a clue to the lie, and which states, "To ourselves and our posterity." If you never saw the title, the Constitution, and you were never told what this document was about, what do you think would be your first impression upon hearing a reading, "To ourselves and our posterity"? The Constitution is not for we the people, and America is a matrix of misinformation. In the eyes of those in control, America is nothing more than a large plantation, and we the people are the slaves. In many U.S. and world treaties, the term high contracting powers is used to define your masters. Everyone else is considered by them to be their slaves. All the Founding Fathers had two things in common. They all shared the gift of a good education or gifted individuals, and they all came from families of business and or substance. These men all suffered from visions of grandeur. They viewed America as their one opportunity to make them powerful and wealthy, to ourselves and our posterity. Initially, their plan was to steal America away from the king, despite the fact that King George funded the exploration of the New World, which legally gave him first claim to all new continents discovered. The seizure of the Americas by the king's explorers was not as it has been depicted in our history books presented to us by our government and our government-controlled public schools. Native Americans, the Indians, were murdered, their villages burned, many were enslaved, infected by disease brought from England, and their lands taken by force and the threat of force by these early explorers. The Indians were labeled savages by these immigrant explorers from England, but the true savages were our English ancestors. One thing the Founding Fathers did not know was that all of the king's lands and all future acquisitions, such as the Americas, have been given in pledge by King John to Pope Innocent III and the Holy Roman Church by the Treaty of 1213. After that fact was proven to the Founding Fathers, King George and the representatives from the Vatican decided to use the constitutional draft created by the Founding Fathers to further their plan to control the colonists. Control attained by bringing the colonists to their knees in debt. Any way you read it, the Constitution was never written with the intent of benefiting the American people. Did you know that 98% of the law schools in America and England do not include constitutional law as a part of their law curriculum? The reason for this phenomenon is because constitutional law does not apply to or affect the enforcement of statutes, codes, or administrative regulations, which have replaced constitutional law, the common law, public law, and penal law, and which have been designed to control you. In other words, constitutional law is taught as an elective at Harvard, Yale, and Cambridge, and only for students of law who are planning a future career in government. This should make sense to you as you read on. The Revolutionary War. In the true history of America, neither side won the Revolutionary War. At first, the appearance of English troops in the colonies was simply a show of force by King George, intended to intimidate the colonists and force them to pay him taxes. Factually, back in England, English soldiers refused to take up arms against the colonists because they were English citizens and relatives. Mr. Mayor Armschell Bauer, founder of the Rothschild banking empire, by this time owned the king. Mr. Bauer had extended unlimited credit to the king and arranged contracts with him, which permitted the Rothschild tax collectors to represent and collect the king's tax from the king's subjects. This is the origin of the concept behind the establishment of the IRS. It was Bauer who suggested to King George that he enforce a tax against the colonists in the New World, since the tax being collected in England was barely enough to pay the interest on the king's loans. When English soldiers refused to fight, Mr. Bauer negotiated a contract with unemployed Russian Germanic soldiers to fight for King George at a cost of 50 cents a day. Bauer then informed King George that he had hired these soldiers in the king's name, but at a cost of $1 a day. King George utilized these soldiers, dressed them in English soldier uniforms, and ordered his career officers to command them. When a show of force in the colonies failed, Mr. Bauer suggested that King George finance the colonists in their war efforts against him and bring the colonists to their knees in debt. The king succeeded in accomplishing this through his appointed civilian figureheads in charge of his government of France. Mr. Bauer wanted to expand his banking empire into the colonies. He discovered that the colonists didn't trade in gold or silver, but used script as the basis of their economy. The script money used were promissory notes printed by the colonists. All the colonists agreed that they would consider these notes the lawful currency of the colonies. Mr. Bauer wanted gold or silver and induced the king to demand that his tax in the colonies be paid in gold or silver. It was that condition that broke the camel's back and caused the Boston Tea Party. Whoever controls the money controls the country. Rothschild. Surreptitiously, King George infiltrated the colonies in their futile attempts to form a new government, using spies composed of English lawyers and English aristocrats loyal to him. The spies' assignment was to infiltrate the new government, carry out the plan to defeat the colonists through debt, and establish regular reports to the king. The church also had their appointed representatives in place to protect and ensure that their interest is being observed. Much of the loans received from the French went into the pockets of the founding fathers. The founding fathers eventually conceded to King George and the Holy Roman Church's demands, by and through the intervention and persuasiveness of the king's spies. Ironically, the common denominator or glue that eventually bound King George, the founding fathers, the English lawyers, and English aristocrats together was a secret society called the Illuminati. Even Paul Revere and Benjamin Franklin were members of the Illuminati. This secret society had a criminal and deadly past in Europe, and in America they were eventually renamed the Free and Accepted Masons. The majority of the regular membership of the Free and Accepted Masons do not know about the Illuminati influence within their rank and file. The Illuminati members operate out of a special secret society separate from the regular Masonic membership and are found in every branch of the Free and Accepted Masons of the world. Think about the colonists who we have been taught to revere by our public school system. All of these individuals were members of this secret society, and all were traitors. Our history books also instruct us to apothecize the founding fathers, but don't hold them in reverence, hold them in contempt. By and through their intervention, slaves you are and slaves you will ever be. An example of a man in history we have been taught to revere is Benjamin Franklin. Would it shock you to learn that he was on the king's payroll and his many trips to England was actually to report on the colonial government to King George? The Declaration of Independence. The Declaration of Independence is another story omitted from our American history books. Of the 51 men involved in the creation of the Declaration of Independence, 21 were actually traitors and on the king's payroll. During the Revolutionary War, English officers were provided the names, addresses, and family members of these 30 loyalists involved in the creation and signing of the Declaration of Independence. The English soldiers had been ordered to hunt down and murder all 30 loyalists, their wives, children, and all relatives, with further instructions to burn their bodies inside their homes. The soldiers were to leave no trace of these men and their families, to wipe out their existence for an eternity. The history of civilizations has taught us all that martyrs are dangerous men of power, and King George didn't want to leave any martyrs. It is pretty obvious who provided the detailed information about the 30 loyalists, their family, and addresses. At first glance, it appeared that Guy Madison of Virginia was so concerned about lawyers holding any position in American government that he championed the 13th Amendment, which barred lawyers from holding any public office in government. The 13th Amendment was ratified, but never made it into print in our government-controlled school books and public classrooms.
The concept that there is no jurisdiction over the people. Okay. And the concept that 14th Amendment took away all judicial power. Okay, guys, it doesn't work that way. You can believe in all this stuff. And if you want to have a discussion on whether or not it's right or wrong, we can have that discussion. But I will give the caveat that it has nothing to do in law and it won't work. The issue is not whether or not it's right or wrong. This is America. We don't care about right or wrong. They have all the guns. Even Ron Paul, when Ron Paul was asked to do the movie, and we went over all this stuff with him, and Ron Paul's a brilliant guy. He's a great guy. We have our issues, but he knows his stuff pretty well. He even said in the movie, and he wanted it in the movie. He was the one that said, yes, put this in the movie. It doesn't really matter what the law says. They have all the guns. So you can sit here and have an argument about right or wrong. I keep a bunch of copies of the original 13th Amendment. You can contact, you can't get it in Arizona, but you can contact the Secretary of State of Colorado. It's $25 for the first one. It's $12 for each additional one. You can just call them up. They'll take a credit card over the phone. You can say, I would like a copy, a certified copy from your office with your gold seal placed upon it of the original 13th Amendment to the United States Constitution. And they will tell you, okay, it's $25 for the first one, $13 for each additional one, or $12 for each additional one. It's such and such for mailing. How many do you want? We'll take your credit card right now. And within about 2 weeks, you'll have these copies of the original 13th Amendment of the Constitution, wherein it states very clearly that to be a lawyer in the United States, you have to give up your rights as a citizen, and you're no longer a citizen of the United States. You're not part of the United States. You have no rights. But you can't go down to the bookstore and buy a copy of the Constitution with that 13th Amendment in there. It was never abrogated. It was never thrown out. There is really the 13th Amendment to the Constitution, not the one that you think there is, because they moved everything down when they got rid of the 13th Amendment. But it's still there. It's still in law. I don't know how you would ever get a court to believe it. They'll lock you up. They have the guns.
The 13th Amendment was ratified but never made it into print in our government-controlled school books and public classrooms. The amendment was surreptitiously removed and replaced by the 14th Amendment. The 15th Amendment became the 14th, and so on. Madison's efforts appear admirable, but his later actions as a member of the First Congress suggest that his only real concern was to block lawyers from undermining the theft that he and his compatriots had planned for America. Once the cost of the Revolutionary War sufficiently placed the colonists in debt, the English soldiers were ordered to dispense with their efforts, recover their arms, and within the next 8 years, they eventually returned to England. The colonists were so glad to see the fighting stop that they allowed the soldiers to retreat and exit America peacefully. There is an old legal maxim that states, the first to leave the field of battle loses. Pursuant to this maxim, the Founding Fathers proclaimed the colonists the victors. A maxim is a legal truth that is time-honored and incorruptible. In reality, the war was just a diversion. The colonists had no chance of succeeding in their efforts. Examine the facts for yourself. During this era, England had the largest army and navy in the world. King George owned England, Ireland, and France, having a combined population of about 60 million subjects. The colonists were poorly educated, poorly armed, and composed of farmers, tradesmen, bonded slaves, women and children, and boasted a total population of only 3 million subjects. And considering the undermining that was occurring to their nation by the king's spies and the Founding Fathers, the colonists didn't have a prayer of defeating the English. Americans have been indoctrinated by our federal and state governments and through government-controlled public schools and literature, government-controlled media, and government-controlled churches. Yes, even the churches, to believe that America defeated the English. We celebrate that victory in our so-called independence each year on the 4th of July, and it is all a bunch of propaganda, a carrot to lead the horse and keep this society stupid and passive. We boast today that our country represents the finest schools in the world, but in reality, we're no smarter than the first colonists. We'll know more about other things because of new technology developments during the last 250 years, and yet the average IQ of America is 70. Documented proof that the Constitution was not for us can be found at Powderford Fay and Company versus Mayor and Alderman of the City of Savannah. This was a court case wherein the plaintiffs sued the City of Savannah for violating what they believe were their constitutionally protected rights. The decision of the judge says it all, but indeed no private person has the right to complain by suit in court on the ground of a breach of the Constitution. The Constitution, it is true, is a compact, but he, the private person, is not a party to it. The Public Trust Fund, Sestweke Vi. The United States Constitution was converted into a trust, and the legal definition of a trust is a legal obligation with respect to property given by one person, donor, to another, trustee, to the advantage of a beneficiary, Americans. The property in the trust includes all land, your personal possessions that you believe you own, and your physical body. The donor of the trust is the King of England and the Holy Roman Church. The trustees are all federal and state public officials, which means that they truly are agents of a foreign power, the King and the Vatican. The reason the Constitution was converted into a trust is because, as a non-trust business plan, the Constitution completely bound the hands of our government officials. By their converting it into a trust, our public officials were then free to make any changes they desired to this government without their constituents' knowledge. The rules of a trust are secret, and no trustee can be compelled to divulge those rules, and the rules can be changed by the trustees without notice to the beneficiary. The one pitfall confronting them in their plan was the fact that by converting the Constitution into a trust, our public officials had to legally assign a beneficiary, and the beneficiary chosen could not offend or be in contrast to the numerous international treaties that were in force. Our public officials wanted to stay in control of the trust as the trustees. However, a trustee cannot also be a beneficiary. So even though the Constitution was never designed or written for the sovereign American people, they unknowingly became the beneficiary of the secret trust, and hence the creation of the propaganda regarding our constitutional rights. All high-ranking public officials, lawyers, and judges laugh at the ignorance of people who claim that their constitutional rights have been violated. Lawyers are actually taught to treat the members of the general public as inferior individuals. This also explains the air of arrogance that most lawyers convey in their demeanor and speech. The more powerful agents of the states and the federal government, however, have been stealing the benefits from the trust through numerous maneuvers that have the appearance of being lawful. In their defense, many former public officials, agents, were not corrupt to begin with, but by accepting bribes or as a result of enjoying an arranged extramarital relationship, they became the victim of an extortion plot and succumbed to the threat to expose the bribe or their illicit affair to their constituents. By becoming an agent, all was forgiven and forgotten. The people who arranged the bribes also arranged the situations and applied the pressure to force honest men to become dishonest. An example of this could be a sudden demand by a bank to pay off a loan based upon a hidden clause in the loan contract, and which could result in a foreclosure, bankruptcy, and scandal. There are no remaining public federal employees in America. All employees who you believe to be a part of America's government are actually agents of a foreign government, and this definition includes the president. The federal elections are a joke on us. All of the candidates have been jointly pre-selected and pre-screened by the national boards of the Republican and Democratic parties well before the election process. All of our federally elected officials, appointed administrators, federal police, and judges receive their paychecks through the Office of Personal Management. OPM is a division of the International Monetary Fund, which is owned by the Rockefeller and Rothschild families and their banking empires, which operates in tandem with the United Nations. The IRS and Interpol are owned by the International Monetary Fund, which has been identified in an earlier version of the U.S. Army Manual as a communist organization. Those Americans who do not know how to assert their beneficiary status are treated by the government and their courts as a corporate fiction. The corporate governments and their courts only have jurisdiction over corporations. Corporations have no rights or jurisdiction over living people and only provided considerations which have been pre-negotiated in contracts by their directors. Otherwise, they're governed totally by commercial law, and so are you. Part 2. At this point, I believe I should address a corporate fiction for you by creating a situation you can relate to. Situation. You've decided to go into business for yourself, and you thought up a clever name for your business. Everything you've read and the advice you received from a lawyer or friend suggests that you should incorporate your business. To incorporate is to create a business on paper. It isn't real. It is a business in theory, which makes it a fiction. The lawyer or accountant you hire to prepare your corporation records your business with the state as a state corporation and identifies you as president on the board of directors, not the owner. Your business is now a corporate fiction, and by recording the business as a state corporation, you no longer own it, the state owns it. You just gave your business away and made yourself an employee. And here we have Hale versus Hinkle. It is a United States Supreme Court case. It was decided in 1906, and it shed some light on the distinction between a corporation and a real living soul. Corporations are beholden to the state, while private, and I want to stress the word private individuals are not. And this is a very interesting case. I think I'm going to do a video solely dedicated to this particular case, because I think it sheds a lot of light on a lot of different things. But here we read, if, whenever an officer or employee of a corporation were summoned before a grand jury as a witness, he could refuse to produce the books and documents of such corporation upon the ground that that would incriminate the corporation itself, it would result in the failure of a large number of cases where the illegal combination was determinable only upon the examination of such papers. Conceding that the witness was an officer of the corporation under investigation and that he was entitled to assert the rights of corporation with respect to the production of its books and papers, we are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for an examination at the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and liberty. His rights are such as existed by the laws of the land long antecedent to the organization of the state, and can only be taken away him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Read Public Rights Doctrine. Up on the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law. It can make no contract not authorized by its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that a state, having chartered a corporation to make use of certain franchises, could not, in the exercise of its sovereignty, inquire how these franchises have been employed and whether they have been abused, and demand the production of the corporate books and papers for that purpose. The defense amounts to this, that an officer of a corporation which is charged with a criminal violation of the statute may plead the criminality of such corporation as a refusal to produce his books. To state this proposition is to answer it. While an individual may lawfully refuse to answer incriminating questions unless protected by an immunity statute, it does not follow that a corporation, vested with special privileges and franchises, may refuse to show its hand when charged with an abuse of such privileges. Our presumed government representatives have done the same thing to each of us. They changed each of us from a sovereign into a corporate fiction. Your corporate name is easily identifiable in that it is expressed in all capital letters on all your documents and all communications received from every government agency. The reason for converting every sovereign American into a corporate fiction dates back to the principle of law under the king. The king is a sovereign monarch and dictator who by his authority creates the laws that govern his subjects. He is the source of law, and therefore the law cannot be enforced against him. In America, the source of law is the sovereign people, and therefore no laws can be enforced against the source, except for those specifically agreed to or defined by the original Constitution. In the course of my research that I'm conducting for another video that I will be posting shortly, I ran across a definition that should put to rest for all the trolls and everything that come on these videos as to whether or not the people are sovereign. And it's a confusion because these people, these trolls, they don't understand that sovereignty of the United States is a qualified sovereignty within their delegated powers coming from the Constitution. But there still remains, in light of the Marshall Court and that decision, and I believe the advent of the 11th Amendment and so forth, of whether the individual is sovereign or not. And there seems to be this consensus amongst those who are not very educated on these subjects that our sovereignty rests in our government. Well, this dictionary, this is an 1880 Bouvier's dictionary, volume 2. And I looked up and I found the definition of United States of America from Judge Bouvier. And they give a variety of definitions, and I want to read this to you so that we can get an understanding of exactly why the people are sovereign. And I'm going to start right here. And you can find a copy of this dictionary at SPC University. Just go, you get a free membership, go in, and under the PDF section, you'll find dictionaries and you'll find it there. You can download it and you can read this for yourself. And you'll see right here it says, the United States have certain powers, the principal of which are enumerated in Article 1, Section 8, running into 17 specific powers. Others are granted to particular branches of the government, as the treaty-making power to the President and Senate. These have an equal effect in all the states, and so far as an authority is vested in the government of the Union or in any department of it, and so far as the states are prohibited from the exercise of certain powers. So far in our domestic affairs, we are a unity. Within these granted powers, the sovereignty of the United States is supreme. Notice it says within these granted powers, the sovereignty of the United States is supreme. The Constitution and the laws made in pursuance of it, and all treaties, are the supreme law of the land. Article 6. And they not only govern in the words, but in their meaning. If the sense is ambiguous or doubtful, the United States, through their courts, in all cases where the rights of an individual are concerned, are the rightful expositors. For without the authority of explaining this meaning, the United States would not be sovereign. In these matters, particularly in the limitation put on the sovereignty of the states, it has been sometimes said that the Constitution executes itself. This expression may be allowed, but with as much propriety, these may be said to be laws which the people have enacted themselves, and no laws of Congress can either take from, add to, or confirm them. They are rights, privileges, or immunities which are granted by the people, and are beyond the power of Congress or state legislatures, and they require no law to give them force or efficiency. The members of Congress are exempted from arrest, except for treason, felony, and breach of the peace, and going to and returning from the seat of government. Article 1, subsection 6. It is obvious that no law can affect this immunity. On these subjects, all laws are purely nugatory, because if they go beyond or fall short of the provisions of the Constitution, they may always be appealed to. An individual has just what that gives him, no less and no more. It may be laid down as a universal rule, admitting of no exception. that when the Constitution has established a disability or immunity, a privilege or a right, these are precisely as that instrument has fixed them and can be neither augmented or curtailed by any act or law either of Congress or a state legislature. We are more particular in stating this principle because it has sometimes been forgotten both by the legislatures and theoretical expositors of the Constitution. It has been justly thought a matter of importance to determine from what source the United States derived their authority. When the Constitution was framed, the people of this country were not an uninformed mass of individuals. They were united into regular communities under state governments, and to these had confided the whole mass of sovereign power which they chose to entrust out of their own hands. The question here proposed is whether our bond of union is a compact entered into by the states or the Constitution is an organic law established by the people. To this question, the preamble gives a decisive answer. We, the people, ordained and established this Constitution. The members of the convention which formed it were indeed appointed by the states, but the government of the states had only a delegated power, and if they had an inclination, had no authority to transfer the allegiance of the people from one sovereign to another. And if they had an inclination, had no authority to transfer the allegiance of the people from one sovereign to another. The great men who formed the Constitution were sensible of this want of power and recommended it to the people themselves. They assembled in their own conventions and adopted it, acting in their original capacity as individuals and not as representing states. The state governments are passed by in silence. They had no part in making it, and though they had certain duties to perform, as the appointment of senators, are properly not parties to it. The people in their capacity as sovereign, 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 made and adopted it, and it binds the state governments without their consent. The United States as a whole, therefore, emanates from the people and not from the states, and the Constitution and laws of the states, whether made before or since the adoption of that of the United States or subordinate to it, and the laws made in pursuance of it. A consequence of great importance flows from this fact. The laws of the United States act directly on individuals. A consequence of great importance flows from this fact. The laws of the United States act directly on individuals, and they are directly and not immediately responsible through the state governments. This is the most important improvement made by our Constitution over all previous confederacies. As a corollary from this, if not more properly a part of it, the laws act only on states through individuals. They are supreme over persons and cases, but do not touch the states but through them. If a state passes an ex post facto law, or passes a law impairing the obligation of contracts, or makes anything but gold or silver a tender in payment of debts, Congress passes no law which touches the state. It is sufficient that these laws are void, and when a case is brought before court, it, without any law of Congress, would declare them void. They give no person an immunity, nor deprive any of a right. Again, should a state pass a law declaring war against a foreign nation, grant letters of marque and reprisals, arm troops, or keep ships of war in time of peace, individuals acting under such laws will be responsible to the United States. They might be treated and punished as traitors or pirates, but Congress would and could pass no law against the state, and for this simple reason, because the state is sovereign, and it is a maxim consecrated in public law as well as common sense, which none of you trolls have, and the necessity of the case that a sovereign is answerable for his acts only to God and to his own conscience. The Constitution and laws made in pursuance of it, that is, laws within their granted powers, and all treaties are the supreme law of the land. And the judiciary, Article 3, Section 1, gives to the Supreme Court the right of interpreting them. But this court is but another name for the United States, and this power necessarily results from their sovereignty. For the United States would not be truly sovereign without their interpretation as well as the letter of the law governed. But this power of the court is confined to cases brought before them and does not embrace principles independent of these cases. They have no power analogous to that of the Roman praetor of declaring the meaning of the Constitution by edicts. Any opinion, however strongly expressed, has no authority beyond the reasoning by which it is supported and binds no one. but the point embraced in the case is as much a part of the law as though embraced in the letter of the law or Constitution, and it binds public functionaries, whether the states or United States, as well as private persons, and this of necessity, as there is no authority above a sovereign to which an appeal can be made. I could go on and on reading this. I could just go on and on, but this should be obvious to anywhere. This is Bouvier's 1880 Volume 2. It's in Bouvier's 1880 Volume 2. It's under the definition of United States of America. Okay, Judge Bouvier is very clear. You have all these people down in the comment section talking about they passed the laws, they changed the laws. It's not within the power of Congress or anyone in the federal government to take away the sovereignty of the people that spoke them into existence. And as this judge said, that should be common sense. Common sense is that sense by which no other sense makes any sense at all. Y'all get this and spread this around and make videos out of it and crush what these people are talking about on the internet and make them look like the fools that they are, because they trying to fool all of y'all. They trying to shame y'all into compliance into a new world order. They want you to be mindless followers and just do what you're told and shut the hell up. Freedom is something that you have to fight for. If you don't know your rights, you don't have any rights. As Thomas Jefferson said, those who hope to be both ignorant and free are hoping for something that never has been and never will be. Those laws are defined as theft, assault, and criminal mischief. But since the colonists never voted on the Constitution, none of these offenses are enforceable against a living sovereign. They are enforceable, however, against a corporation or corporate fiction. Common law grand jury. In theory, and according to the common law, before any sovereign can be arrested for one of these crimes, a complaint must be filed with the elected sheriff. The sheriff, by his own authority, assembles a common law jury of the accused sovereign's immediate neighbors called a grand jury. The neighbors hear the complaint and evidence presented to them by the complainant. They are permitted to ask questions of any witness and can subpoena anyone else who can shed light on the allegations. A majority must then decide if the accused sovereign is to be tried by a court. All this is done without a judge or a prosecutor in attendance. This is a real grand jury proceeding, which is far removed from the joke perpetrated on our corporate government and courts today. What happened to our grand jury rights of old? The Bar Association has successfully stolen that right away from the sovereign people, little by little, through rewrites of the Judiciary Act, so that now the American public believes that the grand jury is an instrument subject to the jurisdiction, right and whim of the prosecuting attorney. The prosecuting attorney controls the entire proceeding and who testifies. The judge then tells the jury what the law is, and the members of the panel are always denied the opportunity to view the written law.
I need to share this with you. Y'all know I'm a lawyer, I'm a former prosecutor, and I'm currently a defense attorney. I was a prosecutor in Manhattan, New York City. So let me explain to you, because we are getting a lot of feedback about these grand juries that are not indicting these police officers, and you need to understand something. The first thing you need to understand is that a grand jury presentation is an ex parte proceeding. What does that mean, Ike? Don't talk that lawyer shit. Okay, ex parte means one-sided. That means that there's only one side being presented in the grand jury. There is nothing to controvert or contradict what the prosecutor is putting in the grand jury, unless a defendant chooses to exercise his right to testify in the grand jury. And even then, the defendant is allowed to come in with counsel, but you as an attorney, me as an attorney, when I escort clients into the grand jury, I am not even allowed to fucking speak. Do you hear me? I'm not allowed to say shit. If I want to confer with my client because he might not be sure how to answer a question, we got to step outside and come back in. The grand jury, the entire presentation is controlled, is orchestrated by the prosecutor. The evidence that goes in, the witnesses that go in, how the evidence is presented, the spin. Prosecutors control the grand jury. There's no judicial oversight. Now, that's not till after you got an indictment. There's no judicial oversight about how the case is going to be presented, what witnesses are going to be presented, what charges are going to be presented. All of that is at the exclusive discretion of the prosecutor. Exclusive. If a prosecutor wants to get an indictment, bet your ass they will get it. They will get it, because that saying, it doesn't take anything to indict a ham sandwich, is fucking true. It doesn't take anything, and I'm a former prosecutor. 5 years, I indicted motherfuckers for 5 whole years. Okay? And I'm telling you, it don't take shit to do it.
He was being tried for 4 counts of not filing his income tax.
Okay.
And our question was, well, what is to decide? Either he did or he didn't. It never occurred to us that he might actually be innocent while at the same time not filing. In the federal government, it is not a felony not to file taxes. Finally, they said, okay, if we're going to get this guy, we're going to have to put it in the state. They called up the IRS agent, Agent Craner.
Craner? Yeah. Robert Craner? Mm-hmm. This is Ken Doherty. He's also an investigator with the Illinois Department of Revenue.
This is a request for a copy of the delegation of authority order.
Right, and I talked to my boss about that, and he said that my badge is that.
Badge is the authority. I thought it had to be in writing.
The last question that the defense asked him was, did you write any of this down? And Agent Craner looked right at him and right at us, and he said, I never wrote anything down. And yet when we saw the video, there he was, writing notes, you know. And so I'm thinking, okay, at this point, the judge is supposed to say, Agent Craner, it is clear that you have committed perjury. It wasn't even noticed. It finally came to the climax. Mr. Harrell looked right at the prosecutor, and he said, I will tell you the same thing I have told over and over again to government officials. You show me the law that requires me to file a tax return, and I'll be glad to do it.
And again, I ask, under what is the requirement that you claim and are required to do these things? And the requirement under the regulations is what section? My question to you is, what particular act are we discussing here that I am liable to do these things that you claim I'm liable to do?
Your exact question would be again? Okay, what is the section that what? But I guess I'm still not understanding your question, Mr. Harrell.
Well, you must be familiar with what that you have the police powers to enforce.
Yes.
The prosecutor absolutely ignored him. And he started slandering Mr. Harrell. Just started attacking his character.
They're calling us tax cheats, they're calling us fanatics, they're calling us weirdos. I don't care what you call me, but I have one question. Where is the law? Show me the law.
They can't let this turn into a rational debate, because if they do, they lose it. So they have to insult people and say it's frivolous.
We felt like that there was an overall arrogance and that they were railroading Mr. Harrell and wanting us to participate. Judge Coogan, he looked right at us and he said, I will instruct the jury according to the law. We were sent to deliberation. The judge promised us that he would give us the law. And we looked and we looked and it was not there. We wrote a note to the judge asking for a copy of the law. 10 minutes later, we get a note back. You have everything you need. But there was no law. And he had promised us. At that point, I felt betrayed. I felt like this man promised us the law, and that's what this whole thing is about, the law. We request it, and he still denies us the law.
And the reason they didn't do it was why?
Because there is no law.
All of our governments are corporations and are responsible for the creation of about 800,000 laws called statutes, which are designed to control the sovereign people of America. Just like the king, these statutes cannot be enforced against the source of law, which are the living, breathing, flesh and blood sovereign people. All of the agents in power, beginning with the king, the Vatican, the founding fathers, and now presumed public officials, wanted to obtain power and control over America, and the Constitution pretty much prohibited them from achieving those ends. So they began to devise ways to change the sovereign Americans into a corporate fiction. These agents also decided and reasoned that they cannot educate the masses without exposing their treachery, and so our private and public education must be controlled. Without any real constitutional basis, the U.S. Department of Education was created. The Constitution made it the responsibility of each state to educate their people, and several states challenged the Congress and the courts. The matter was eventually heard by the U.S. Supreme Court, which has never been a constitutional Article III court from its inception, which I will explain. The Supreme Court ruled that the federal government was entitled to oversee the educational requirements of United States citizens by virtue of their constitutional powers to regulate commerce. Bad law is bad law, no matter how you turn the paper, and that ruling gave the federal government the green light to initiate its brainwashing process of the American public. Let me explain how the court arrived at its ruling, because these are not ignorant men. On every form you file to receive a government benefit, and even the voter registration form, there is a question that asks, are you a United States citizen, yes or no? And everyone circles the yes answer, didn't you? Now look up the definition of a United States citizen in a reputable law dictionary. You will discover that a United States citizen is a phrase designed to identify a corporate fiction. Clever, isn't it? You and every other American had no idea that you were admitting you were a corporate fiction when you circled that yes answer, and you did it under penalty of perjury. The sovereign states had been abolished in 1790 by the adoption of Article 1 of the Statute at Large, which converted all the sovereign states into federal districts and gave the federal government lawful jurisdiction everywhere. In consideration of the fact that the federal government is a corporation and that corporations can lawfully own other corporations, and all the American subjects to be educated have admitted under penalty of perjury that they are corporations, the Supreme Court ruled in favor of the corporate federal government. See how sneaky and tricky lawyers can be? And all the more reason why lawyers should never be allowed to serve in government or in judgment of us. Under our corporate governments, no sovereign can lawfully be tried or convicted of any statutory crime. I recently discovered how to avoid prosecution under the trust when a sovereign is taken before a corporate prosecuting attorney or a judge. First, the sovereign must inquire if we are on the record, and if not, insist upon it. Say nothing, sign nothing, and answer no questions until you are convinced that the proceedings are being recorded. Secondly, all the sovereign has to say for the record is, I am a beneficiary of the trust, and I'm appointing you as my trustee. Thirdly, the sovereign then directs his trustee to do his bidding. As my trustee, I want you to discharge this matter I'm accused of and eliminate the record. Fourthly, if the sovereign suffered any damages as a result of his arrest, he can direct that the trust compensate him from the proceeds of the court by saying, I wish to be compensated for X dollars in redemption. This statement is sufficient to remove the authority and jurisdiction from any prosecuting attorney or judge. The accused will be immediately released from custody with a check, license, or claim he identified as a damage. It doesn't matter what the action involves or how it is classified by the corporate law as a civil or criminal action. It works every time. All of the codes, statutes, and regulations throughout the United States are a will from the masters to their slaves. A will is defined as an express command used in a dispositive nature. When individuals in America are charged with a crime and warehoused in a jail, it is because they went against the will of the masters and not because they harmed another person. Remember that. The will demands from us all that we are, keeps us in check, and promises us nothing. The police officer who arrested you has been brainwashed into believing that he is doing the right thing when in fact he's nothing more than an armed slave acting as a henchman and hired to bully and intimidate all of the slaves into submission of the master's will. This statement will probably offend most police officers, but this is a fact and it is not their fault.
As far as I know, you have not done anything wrong at this point, but you are slowly reaching to that point to 148 PC.
I'll get out of the vehicle for you. I will get out of the vehicle. I'm getting Mama.
All right, well, you're not free to leave. You're going to take the bag off.
No, I'm not.
You're going to take the bag off.
No, I'm not.
Relax your...
Hey! You're raping me. This is rape. This is rape. This is rape.
Relax.
Okay.
Relax your arms.
It's relaxed.
Stop fighting with me.
It's relaxed.
Stop fighting with me. Stop fighting.
All right? I'm not fighting.
As far as I know, you have not done anything wrong at this point. As far as I know, you have not done anything wrong at this point. As far as I know, you have not done anything wrong at this point.
Most police officers believe they are performing a public service and doing the right thing in the performance of duty. They have been lied to by the government, and in most cases, police officers are pumped full of lies more so than anybody else. Recently, the police have been ordered to complete paramilitary training and were told that this is essential because of new threat of terrorism. The people responsible for this training and brainwashing are the same people and foreign agents who have been controlling all of us since our birth. Note, I bet that nobody told these police officers that these suspected terrorists may come at them from their very own government officials. So now our government officials have our police officers training to act like a military unit. In other words, follow our orders and don't think. They have succeeded in placing these officers on edge so that their every reaction will be an overreaction to the situation, just like Hitler's Gestapo. Near the end of this paper, I will disclose to the reader about a situation that has been planned by our government officials and is soon to unfold. The police paramilitary training and their extensive brainwashing has been implemented specifically for this event. It is expected that police officers will overreact and begin killing innocent Americans, and once they are no longer of use, the officers and their families will all be ordered to receive vaccinations that will kill all of them. My guess is that after this planned mass genocide has occurred, the Russian and Chinese military will replace them in the field. Part of the fraud perpetrated against we the people by this will is the fact that there are actually no criminal laws in America. The rules of procedure used by every local, state, and federal court are civil rules, not criminal. Court officials simply substitute the word criminal for civil, depending upon the case at hand. Rule number 1 of the Rules of Civil Procedure reads, there should be but one form of action, a civil action. This means that the criminal laws promulgated and enforced by the police and our corporate governments are all civil and are being fraudulently enforced against our corporate fictions as criminal. When anyone goes to jail, it is for a civil infraction of the master's will that makes all of our jails debtors' prisons. Does that ring a constitutional bell? Title 18, Federal Crimes and Offenses, was never voted on by the Congress, which means that the federal laws are not positive law in America. Now, if you were a part of a government conspiracy to destroy America and soon to commit a mass genocide of its population, would you really want to vote Title 18 into positive law? My belief is that the Congress intentionally omitted its passage so that members of Congress could use that as a defense should they be caught and tried for treason. Do you believe the lawyers hired or appointed to represent all the individuals accused of federal crimes knew about this fact? You bet they know. Armed with this fact, now look at the number of convicted people sitting in federal prisons who believe that they have been lawfully convicted of violating a federal crime. How many do you imagine have been put to death? How many were shot and killed during the arrest? How many were killed attempting to escape from their illegal confinement? The Internal Revenue Code relies upon Title 18 to convict people of tax evasion, which only applies to corporations. Look at all the people sitting in federal prisons who were convicted of these so-called crimes. What makes it worse is the fact that the Queen of England entered into a treaty with the federal government for taxing of alcoholic beverages and cigarettes sold in America. The treaty is called the Stamp Act, and in this act, the Queen ordained that her subjects, the American people, are exonerated of all other federal taxes. So the federal income tax and the state income taxes levied against all Americans is contrary to an international treaty and against the sovereign orders of the Queen. Like it or not, the Queen is our monarch and master. The tax is illegal, and still people have been prosecuted and imprisoned contrary to law. 100% of the people sentenced and held in all American jails have either been convicted of crimes that are not positive law or convicted of civil crimes and are being detained there by their consent. That's right. The lawyers and judges representing our legislature and judicial system created maneuvers to ensure that anyone who is accused of a so-called crime and posts bail signs a contract to appear and consents by that contract to the proceedings scheduled. Anyone who applies for a public defender signs the same contract without knowing it, and anyone who privately hires a lawyer to represent them in a court proceeding consents to the same contract upon the lawyer filing a notice of appearance. When you hire a lawyer, you sign a power of attorney. He is required to file his notice of appearance in that case, and that notice of appearance offers your consent and binds your appearance to the proceedings. The Revolutionary War. Absent the aforementioned contracts, the court cannot proceed against you. When that occurs, the judge and the prosecutor attempt to trick and intimidate you into giving your consent. If you don't know how to invoke your sovereignty, and you take what they throw at you and stand your ground, they'll be forced to release you after 72 hours has elapsed. I'm not a bleeding heart liberal who believes that we should open up the jails and let everyone out. There are people in our jails who need to be there, despite the fact that they have been incarcerated illegally. My vote is to leave that hornet's nest alone. We Americans are so proud of the fact that we live in a democracy. Now look up the word democracy in a reputable law dictionary and see the legal meaning. Democracy is defined as a socialist form of government and another form of communism. Do you remember the lies that President Reagan, the Congress, and the media told America? The lie was that the Iron Curtain fell without a shot being fired. The truth is that the Iron Curtain came down because communist Europe found an ally in the West, and there was no longer a need for walls. P.S. Your federal taxes constructed the world's largest automated vehicle and munitions plant for the Soviet Union during the dismantling of the Berlin Wall. P.P.S. The attempt to assassinate President Reagan occurred because he had disclosed to the American people that none of the federal income tax paid by the American people is ever deposited into the United States Treasury and is being deposited into the Federal Reserve Bank for its use and benefit. Congressional Research Service, the Library of Congress, Grace Commission. And here we have a copy of the Grace Commission report. And you will see quite clearly right here, tells you very clearly. With 2/3 of everyone's personal income tax is wasted or not collected, 100% of what is collected is absorbed solely by interest on the federal debt and by federal government contributions to transfer payments. In other words, all individual income tax revenues are gone before one nickel is spent on the services which taxpayers expect from their government. And this was commissioned by Ronald Reagan. And if people remember back when Reagan got shot, it was shortly after this announcement by the Grace Commission that Ronald Reagan got shot. He told the general public, all the taxes that you're paying are not going to any of the services that you expect. 100% of your taxes are going to pay back the national debt to the Federal Reserve. Who is the Federal Reserve? Who are the beneficiaries? What is the Federal Reserve? It's a private bank. It's a central bank. Shortly after making that statement, Reagan was shot by John Hinckley, who was quickly declared insane so that there never would be a public trial. If you recall, President Reagan was never the same after the incident. The masters don't play around. They eliminate problems or radically curb attitudes. Constitutors. On September 17, 1787, 12 state delegates of the 13 state colonies approved the United States Constitution, not the colonists, and by their doing so, the states became constitutors. A constitutor is defined under civil law as one who, by simply agreement, becomes responsible for the payment of another's debt. See Black's Law Dictionary, 6th edition. Many early immigrants to the United States arrived here as bonded slaves. A person of wealth or substance became the payor by offering to pay or promising to pay or bond the debts of another person, and usually paid the cost of his or her voyage to America. This made the payor a constitutor and gave him title as master over the debtor's slave by written contract. A bonded slave is a corporate fiction. The payer's new title and power as the bond master of the debtor causes the immigrant to become a bond slave and the property of the master until such time he is paid back his investment by the bond slave or by someone else. This means that the bond master can buy and sell these contracts. If a bonded slave was mistreated by his bond master, the law did not represent him because the bond slave, a corporate fiction, had no human rights afforded to him by any law. Corporate fictions have no rights. If the bonded slave desired rights, he was obligated to negotiate them in his contract with the bonded master before accepting the contract. If the bond slave runs away from his abusive bond master, the law in place, however, attached a bounty, hunting him down and returned him to the bond master. Remember also that the first slaves in America were Indian and then Caucasian, of English, French, Irish, and German ancestry. The Constitution is not for we the people. As mentioned before, the colonists were never presented the Constitution to vote on its passage and approval because the Constitution was never written for them and has been rewritten 2 or more times since then, but only our government officials know about that. And now, so do you. Number 1. Article 1 of the Constitution allows the Congress to borrow against the full faith and credit of the American people without end. It keeps us eternally in debt and makes all loans the government receives from the king or any other entity valid and enforceable against we the people. How is that good for us? Number 2. Article 1, Section 8, Clause 15 of the Constitution reads that it is the militia's job to execute the laws of the Union. The militia is a military unit, something like the police or National Guard, and is composed of members of our local community. The new state constitutions, however, make militia illegal except in time of war and authorizes the police to arrest the members of a militia should they attempt to reform their ranks. How is that good for us? Number 3. Article 1, Section 8 of the Constitution gives the Congress complete power over the military. What do we do when it's the Congress who we need to have arrested for treason and peonage? How is that good for us? President Obama has changed the military oath. Soldiers no longer swear to support or defend the Constitution, but rather to support and defend the president. Now, isn't that convenient? Number 4. Article 6, Section 1 of the Constitution is the law that makes American citizens responsible to file income tax returns, and not because of Title 26 of the United States Code. Parts of our flawed history, taught to you by our government-controlled school system, accurately describe that the English people had been taxed into a state of poverty by King George and was one of the reasons the colonists fled Europe for the New World. So how is this good for us? The Internal Revenue Service. The IRS is not a U.S. government agency. They are agents of a foreign power, operating under a private contract, and your obligation to pay and file federal taxes is a scam. Only federal employees and persons born in Washington, D.C. and the federal territories were ever obligated to pay and file prior to the Stamp Act, but we were never informed of that fact. Our government has brainwashed us into believing that the national debt is all our responsibility and a patriotic responsibility to pay our fair share. Here's the truth about that subject. The national debt is a federal debt and always has been. The name change was the clever use of propaganda intended to invoke our civil patriotic pride. The foreign agents in charge of our government have been borrowing funds to line their pockets with, to buy influence, make business deals, and seal treaties with communist third world countries and dictators which will never benefit we the people. They have lied to us, enslaved us, imprisoned us, and sold our gold to the Vatican in 1933 and invested the proceeds for themselves. The money they have been borrowing since 1933 is not real money, but negotiable debt instruments, which is the same thing as monopoly money. This means that in order to pay off the federal national debt, all they ever had to do was print a money order without any account numbers on it for the entire debt, sign it, and present it to the lender, the Federal Reserve Bank, and the debt is paid in full. The foreign agents who purport to be our public officials are responsible for eliminating the strength of the American labor unions, the elimination of our jobs, the erosion of our inalienable rights, and have instigated every war or conflict we have ever become involved with in history, and they convinced us that it was the other guy's fault. They have converted us into corporate fictions and sold us as securities to foreign corporate investors, and have denied us our heritage. Everything they have been doing is designed to undermine our freedom, liberty, and representative form of government. Their goal and final blow against we the people is our mass genocide and the total conversion of our government to communism. Number 5. The 16th Amendment to the Constitution, regardless of the dispute of how it was adopted, permits the federal government to assess and collect a direct tax against we the people. Most Americans do not know that the federal government is, and always has been, financially self-sufficient, the result of tariffs imposed upon imports, exports, and commerce. Not one penny of the direct federal income tax paid through the IRS is ever for or deposited into the United States Treasury. Those taxes are deposited into the Federal Reserve Bank for the master's use. So how is this direct tax good for us? You may be wondering about now how the United States government can collect taxes from we the people when we are slaves, own nothing, and are not a party to the Constitution. Despite its legality, it is done under a process known as debt collection through private contractors, the IRS, and through a private contract, the United States Constitution. The International Monetary Fund. The IRS belongs to the International Monetary Fund, who also owns the Federal Reserve Bank. The IMF holds the controlling interest in all the banks in America. The IMF is the Rockefeller and Rothschild empires, along with the 11 wealthiest families in the world. When you see or hear of a bank closing, it is a diversion and is intended to injure and panic the public. The condition of the economy in the world today is being manipulated by these people. The schedule for the adoption of the New World Order is close at hand, and these public agents need to scare us into believing that this new form of government is our salvation. Factually, it will only be good for them, and it will be our ruin. Number 6. Article 12 of the Articles of Confederation promises the full faith and credit of the American people to repay all loans made by the United States government. The money borrowed by the United States to finance the Revolutionary War came from France. Who owned France? King George. Who was the opposition in the Revolutionary War? England. Our founding fathers promised our labor, equity, full faith, and credit to repay those debts that will, in theory, never come to an end. So how is that good for us? Number 7. The Bill of Rights was not for your protection. There are laws that represent one man's ability, with the assistance of the state, to control another man's actions, and since they're included under the US Constitution, they're not for you. So how is that good for us? The 13th Amendment barred lawyers from ever holding a seat in public office. The amendment was ratified, however, during the second secret writing of the Constitution. This amendment was dropped and replaced by the 14th Amendment, and the 14th Amendment was replaced by the 15th Amendment, and so on. The replacement wasn't done by a constitutional convention. It was simply omitted. The original Constitution is the law of the land and was designed to regulate our government. The 13th Amendment still is positive law, but now about 98% of our public officials are lawyers. So if we filed motions to remove them from office, who would sign them? Wasn't that convenient for them? Number 9. On August 4, 1790, Article 1 of the U.S. Statutes at Large, pages 138 through 178, abolished the states of the Republic and created federal districts. In the same year, the former states of the Republic reorganized as corporations, and the legislatures wrote new state constitutions absent defined boundaries, which they presented to the people of each state for a vote. Why this time? Because the new state constitutions fraudulently made the people citizens of the new corporate state. A citizen is also defined by law as a corporate fiction. The people were bound to the corporate state, and the states were bound to the corporate United States, and fraudulently obligated all of us to pay the debts of the federal government owed to the king. This was necessary because the United States was officially bankrupt on January 1st, 1788, and the politicians, our founding fathers, who benefited the most by these revolutionary loans, required a guarantee to present to the king. Absent that guarantee, they were personally obligated to repay the debts. The state constitutions were rewritten again during the Clinton administration, except now they are called the Constitutions of Interdependence. These constitutions read just like the Declaration of Independence, except that we the people have been eliminated. This is the Magna Carta of the public officials to protect them under the New World Order communist government. The public was never informed of this, like everything else, and the media never reported any of the fraud being perpetrated against America by their public officials. I could go on discussing articles and amendments of the Constitution, but suffice it to say that the benefits the government dangled in front of our naive noses has been used as an inducement for us to volunteer, and that all these benefits are received by us at a terrible cost. When we apply for government benefits, the foreign government in charge converts our living sovereign person into a corporation and then records our person as government asset property. The state used to provide protection, stability, and security for the people, but over time the focus of their attention has changed to the control of our minds, bodies, spirit, and assets. To take a loyalty oath to support, defend, and obey the Constitution now is to swear an oath to your masters to be ever loyal to them. Slaves you are, and slaves you will ever be.